Hello and welcome to a special interview for The Wire supported by Glenlivet Books. Although almost 2 years have passed since the Supreme Court announced its Ayodhya judgment, it's still the source of considerable controversy. A lot has been written about it, many people have quarrelled about it, but actually no one has written in such detail and comprehensively as the author of this book. Here it is, it's called Sunrise Over Ayodhya, Nationhood in Our Times. It's a book that will be published next week, but today its author is with me. He's former law minister, former foreign minister, and now a leading Supreme Court advocate, Salman Khurshid. Salman Khurshid, before we come to details, let me start with a simple question to set the scene for the audience. The key argument in your book is that because the Ayodhya case is a title dispute regarding a disputed property, it can only be judged and determined in terms of evidence, not faith and belief. And secondly, you say, because the Supreme Court believes that the evidence of possession produced by the Hindu side is better than the evidence produced by the Muslim side, it was right for the court to find in their favor and give them the land. Is that a correct summary of your argument?
I think well, almost the correct summary. It doesn't differ with what I believe. The Supreme Court itself said this is a title suit. So that's very clear. The Supreme Court did look at various other issues about faith and so on and so forth, but gave very clear answers that that was not relevant at all. As far as the evidence on the title suit is concerned, the Supreme Court finally said, yes, the evidence given by the Muslim side is not as good as the evidence given on the other side. So it was very precariously balanced. And looking at the overall context, the Supreme Court said the best thing to do is to give Muslims land somewhere else nearby and let this land remain with Hindus.
Okay, with that in the background, let's now come to details. First of all, the judgment says, and I'm quoting, there is no evidence whatsoever that after its construction it was ever used as a mosque by Muslims at least till 1856-57. Historical or other evidence is not available to show the position of possession or offering of namaz in the disputed building till at least 1855. But there's a simple answer to that problem. Just because I can't prove I owned something 500 years ago doesn't mean I didn't own it. It simply means the records are lost. Why could the Supreme Court not accept that?
Well, there is a principle called the lost grant principle. The Supreme Court did consider that at considerable length. Parallel to that, there is a concept of waqf by user. So if there is a waqf established by user, if the use stops for a short while or for whatever period, that doesn't mean that the waqf has ceased to be a waqf. They considered both these principles and tried to apply it to the facts of the case. What astounds me, surprises me, and amazes me is that they actually had to come to a conclusion that the Muslim side didn't give evidence of uninterrupted use. Now that is unusual. I mean, it's like looking
and close to impossible, because remember, we're talking of uninterrupted use stretching over 5 centuries.
Well, that's it. So somebody could have given some evidence. I just don't know, because I wasn't there. I don't know why evidence, even if it was weak evidence, wasn't provided. I mean, it's just very surprising.
Well, but the question is not just why wasn't evidence provided. The question is, what sort of evidence could there possibly be? I'm going to quote to you Justice Karju, a fairly eminent former judge of the Supreme Court. This is what he says about the Supreme Court's insistence on evidence. And I'm quoting him. What evidence could possibly be adduced? There can't be eyewitnesses alive belonging to that period, and it's well known that in 1857, during the War of Independence, almost all records in Awadh were destroyed. In any case, he says, it is common sense that when a house of worship, whether a temple, mosque, church or gurdwara is built, it is built for use, not just for decoration.
Well, I think that's a very important observation. And one would imagine in the normal course, one will assume that something built for a purpose, particularly for worship, would have been used for worship. But there are evidences available in these kind of ancient matters There are travelogues, there are contemporary records such as who was appointed imam, records such as who were the people who actually went there. Now, it's surprising that there wasn't a shred of evidence produced. The court could have rejected that evidence, but that's not what has happened. The court is saying we are absolutely helpless, that both at the lower level, when the matter was heard by the High Court, and here, we've asked repeatedly for evidence and no evidence
You're
is being
making
given.
a very interesting point. You're actually saying that evidence of some sort about imams and about other records that were available did exist, but wasn't given by the Muslim side to the court.
I don't know.
That's what you're saying.
It must have been there. It must have been there. There must have been money spent on the building or the structure from time to time. There is, in fact, some evidence that was produced to show that after one of the attacks that happened, some money was given by the administration for repair of the mosque. But that goes both ways.
No, but let me just interrupt you there. Was this evidence not made available to the court, or is it that it was made available, but the court didn't consider it good evidence?
No, this evidence that I've spoken of was made available. That evidence was available, but that evidence cuts both ways. It cuts into interruption and also of
I'll
use.
come to the fact that it cut both ways. The most important point you're saying is evidence was made available, and therefore there was a case that was presented by the Muslim side that we have been in ownership from the date of construction 1528 right up till 1856. It's just that the court didn't think the evidence given by Muslims was as good as the evidence given by Hindus.
Well, that's what it's turned out to be. It's quite possible. It's quite possible that despite all this, a court could have come to a conclusion saying, well, surely there are assumptions, surely there is a natural conduct to be assumed by a court, judicial notice to be taken. Therefore, we will accept that this is a mosque, particularly because they came to a conclusion that there was nothing actually destroyed or demolished to make this.
Those are arguments I'll come to in a moment's time. Those
Yeah.
are arguments to do with other assumptions the court would have made on the basis of history or on the basis of usage or on the basis of the point Karju makes, that if a house of worship is constructed, it is for use, not for decoration. But the first point I'm pointing out is the question raised by Karju: what sort of evidence could exist? He claims all records were destroyed during the War of Independence in other than 1857.
I think that's a bit exaggerated, because 1857 all records in all places were not destroyed. Records were available, and in fact many records have been produced which didn't point sufficiently towards the cause that was being established.
Let's then come to a second point, again made by a former Supreme Court lawyer, and once again it's about the Supreme Court's insistence on evidence. This time it's Justice Ganguly, who is a very learned Supreme Court judge in his time. He says, and I'm quoting him, "The court has no duty to recreate history." And he adds, "Who owned the land 500 years ago? Does anybody know? What was there 5 centuries ago is not supposed to be known by the court." Now, what he's saying is, the court is exceeding itself by trying to establish the facts of history and go into disputed facts or try and search for facts that may not be available. This is not a matter for the court to go into. In fact, at another point he says, this all happened before the Republican Constitution of India came into being. Don't go into the matter. That's another point he makes.
Well, that's a very valid view. I mean, a court could have come to that conclusion. What the court could have said, that we only look for the limitation period. We don't look beyond the limitation period. But the last few years, there had been a dispute. There were people trying to push in, people trying to place things there, etc., etc. So the court couldn't have limited itself to that limitation period. It tried to go beyond the limitation period to understand what the root of the title was, and the root of the title couldn't be established.
This is the problem. The court tried to go back 5 centuries to 1528, looking for credible evidence that would establish that the Muslim side was in possession. As a result of this, what I would call unnecessary search for evidence, it actually ended up tying itself in contradictions, because on the one hand, the court says, and I'm quoting, "There is no proof of namaz happening in the mosque between 1528, which is the date of construction, and 1856-57. But on the other hand, the same judgment accepts that this is a mosque, and it accepts that it was never abandoned. Now, the court can't take up the two positions together without contradicting itself. If it accepts it's a mosque and wasn't abandoned, ipso facto namaz was happening there. In which case, you can't say we have no proof of namaz. The very fact you've accepted it as a mosque is proof of namaz.
Well, not proof, assumption. And I accept that these point in two different directions. And there are many other decisions that the court took, which points to one direction rather than the other. But the essential thing is that once you say this is a title dispute, in a title dispute, whoever is claiming title has to come with a certain amount of evidence to claim title. And if you don't succeed in doing that, then you are unable to claim title or unable to prove title.
Technically, you're absolutely correct. I'm not disputing the technicality of your argument, but when you're claiming title or ownership of a property that was constructed in 1528, 5 centuries earlier, the court must realize a lot of titles and a lot of evidence won't exist. And therefore, side by side with the nature and quality of evidence that's available, you should add in assumptions. The first assumption is that if a building is built as a mosque, it's to be assumed it will be used as a mosque, particularly if the court accepts it is a mosque and was never abandoned. But there's a second thing. The outcome the court came to also flies in the face of history. After all, this mosque was constructed in 1528, at which time Babur was the conqueror of India, not just emperor, conqueror of India, and it was built in his name. Then, in 1658 to 1707, his great-great-grandson Aurangzeb was emperor of India and widely known to be a bigot. Is it at all plausible that he would have permitted Hindus to enter and worship in a mosque named after his great-great-grandfather? And yet, the logic of the position the Supreme Court ends up taking suggests this is quite possible. It's illogical to believe it, but it flows from the Supreme Court's position.
That's the problem. That's why I say it could have been decided purely on a matter of faith, which meant that you look at two separate faiths and decide where do we stand, or on principles of law, principles of property, principles of title.
But I'm not quarreling with you. I agree that it shouldn't be decided on the basis of faith because it's a title dispute over a disputed property. What I'm saying is, you can't simply decide who is the owner of the title on the basis of the quality of evidence available, because this is 5 centuries old and evidence won't be. Therefore, bring in assumptions, bring in history, bring in logic. That the Supreme Court refused to do.
No, I don't think that's true. The Supreme Court looked at a lot of history. Supreme Court looked at a lot of travelogues. Supreme Court looked at a lot of records of people who had gone to Ayodhya over a period. The only thing is that this is not going back to the times of Babur or Akbar, etc. They were obviously later, much later, but the records were there. Unfortunately, they all pointed to one direction.
No. The problem with the records that the Supreme Court looked at only go back to the beginning of the 18th century.
Yeah, that's what.
And they're mainly European records. By the way, the Supreme Court didn't look at any Sanskrit or Hindi written records. That's pretty clear. Why it didn't do it is another matter, but it didn't. The problem is the Supreme Court says to the Muslim side, from 1528 when the mosque is constructed till 1856, we don't have convincing evidence from you that you owned it. We don't have convincing evidence from you that you had exclusive use of it. That's where I say history comes in. I mean, would a mosque built when Babur had conquered India in his name not be exclusively for Muslims? During Aurangzeb time, a man who's considered a bigot would be exclusively for Muslims?
But you want me to be the devil's advocate. I would very happily argue that. But the Supreme Court did not rest the case on assumptions.
Absolutely.
Those assumptions, you may say that those assumptions would have been logical, assumptions would have been objective, assumptions were acceptable, but they didn't make those assumptions.
But there's something else.
Yeah.
By putting these blinkers, evidence and only evidence is what we're going to consider. Not only has the Supreme Court narrowed its vision to a point where history, where the fact it recognizes the building is a mosque, all of that is ignored, and that seems illogical, if not actually foolish, but something else.
I would be careful about using the word foolish for something the Supreme Court does. You may disagree with it, but it's not.
I would actually argue that it's foolish to disregard history and end up with an outcome that flies in the face of history. But I don't mean to be rude to the Supreme Court. I'm not calling judges fools. I'm just saying that the outcome is foolish. What I'm also pointing out is this. If you put these blinkers, and we'll only go by evidence, then ipso facto, you're pursuing a path that will favor the Hindus.
Well, I mean, you could say that, but don't forget that there were two parts of Babri Masjid, or what was called Babri Masjid. One part was the Chabutra part, which is on the outside of the courtyard. And that was an undisputed admission by Muslims that that's where
since
the prayers did happen.
1856. Since
Yeah,
1856.
the prayers did happen, but you don't have to go beyond that, because the latest position was that they conceded this is where prayers happen.
I'll finish that argument for you, which makes the Supreme Court's position even more bizarre. The Supreme Court said since 1856 the outer courtyard was in the possession of the Hindus, and no one disputes that. The inner, the Muslims claim, was in their possession, but the Muslims can't prove it.
No, disputed, not disprove it. There was also a dispute raised by the other side. You may reject the dispute, but the dispute was raised by the other side.
But hang on a second. One of the arguments put up by the Supreme Court is that when the Hindus prayed in the outer courtyard, they did so looking at the inner courtyard, telling themselves, one day we'll be there, and that's where our God was born. That's tantamount to saying that if I look at my neighbor's house every day and covet it and say one day I'll be there, that somehow gives me the right of possession to it. The argument is the same.
No, not the right of possession by merely hoping that you will one day establish yourself there. But the right of possession, if you periodically run in there, place a plaque or place a flag or place a signature and say, I was here, this is mine, and then you go back. The other side...
This is very interesting.
Other side can't
if
say.
a thief or a vagabond occasionally or periodically enters your home, right, and deposits a flag or a jhanda or drops his handkerchief, right, he can claim the right of possession because he came in and did it 4 or 5 times in 3 centuries.
Absolutely. That's what the law of limitation
But
is.
frankly speaking,
if
this is the basis on which it's given to Hindus, do you remember that wonderful phrase, the law is an ass?
No. You may say that, but the point remains that there is a standard law of limitation. If you have adverse possession against the real owner for a certain number of years,
it becomes yours.
Now, this is the law. It should not be the law is another matter, but it is the law.
Absolutely. I'm not denying it, but side by side, what makes the situation bizarre is what I'm now going to turn to, because I think it's very important.
Yeah.
This is where the Supreme Court's outcome becomes truly disturbing. Once again, I'm quoting from the judgment. On a balance of probabilities, very important phrase. On a balance of probabilities, the evidence in respect of the possessory claim of the Hindus to the composite whole of the disputed property stands on a better footing than the evidence adduced by the Muslims. Now, in simple English, that simply means both sides produced evidence, but the Hindu evidence was better. If that is truly the case, I would say that is an excellent argument for splitting the property and giving it to both sides. Maybe not equally, perhaps disproportionately, but clearly if the Muslims have established some sort of evidence, they have a claim to it. What does the Supreme Court do? It doesn't split it between them, not even disproportionately. It gives the property in its entirety to the Hindus. That is clearly unfair.
Well, the Supreme Court is the only court that could have done that, could have split it under 142.
Why didn't it?
Article 142.
Why didn't it?
Now, I think that's where a very critical dimension comes in. By splitting it and giving just a little small piece to the Muslims and the entire area around that given to the people who were advocating for the temple, would have not closed this issue.
But the Supreme Court's not in the business of giving political closures, because it's not a political body. It's in the business of justice, and you're being unjust. You're being unjust if you accept
but
that
please
there
tell
is
me
Muslim evidence, and yet you ignore it.
Court didn't ignore it. You yourself said, the court said, on a balance of probability, their evidence was better. How else do you decide a case? On a balance of probabilities.
Hang on a second. This is not a normal case to do with something that happened in the 20th, 21st century, where the evidence is all available and is beyond dispute and all possible evidence has been made available to the court. This is a case that goes back 5 centuries where evidence is missing, as Karchu said, and I'm repeating him, what possible evidence could be adduced? Judges should have kept that in mind.
I'm sure that,
Therefore, on a balance of very strange probabilities based on very limited evidence, realizing that for a lot of the time the evidence has been missing, they've ended up giving it to the Hindus.
See, all this is very easy to say if you're not actually sitting with the record and you're not actually sitting with the documents to say, well, this document is very persuasive, this document is very strong evidence, why don't we use it? Any judge sitting there may have to do the weighing in process. But at the end of the weighing in process, the judge comes and says, you've got better evidence.
There's another alternative also. One is, balance of probabilities means both sides have a claim, even if one is not as good as the other, split it.
Yeah.
The Supreme Court chose deliberately not to. I'm saying it should have. It was unjust not to split it. It was unjust to give it entirely to one side. But there's another possibility. The Supreme Court could have said, this is a title dispute, we accept. It can only be determined on evidence, not faith and belief, we accept. However, we don't have requisite evidence going back to 1528. It's been lost, it hasn't been available, and therefore we are not going to determine this title suit because we don't have the evidence on which to do it rationally, logically, and fairly.
That option is never available in law. You can either say no to a plaintiff or you can say yes to a plaintiff.
Then they should have said no.
Now, if they said no to the plaintiff, then things would remain as they were.
Absolutely.
Then they
but
would
as I
remain
said to you, the role of the Supreme Court is to be just and to give justice, not to politically adjudicate and heal. That is a politician's job. The court's job is justice. The court hasn't done justice. It's arguably been unjust.
No. I think that's unfair. When you say the court doesn't have to heal, and court does justice.
The court is not Mother Teresa.
No, the court is not Mother Teresa, but the court is a lot of things. Court has compassion, court has concern, court has feelings for the well-being of the people, etc. It's the totality.
Those feelings of compassion are usually shown at a time of flood or disaster, not necessarily when you're adjudicating a title suit.
It's called equity and good conscience. When things run out in law, you go to equity, and equity with good conscience lets you find a solution that is acceptable or good for everybody.
Let me point out to you that the outcome the Supreme Court ended up with, handing the entire property to the Hindu side, actually seems absurd when you look at other comments the Supreme Court has made. The Supreme Court said the way the idols were brought into the mosque in 1949 was a desecration. The Supreme Court said the demolition of the mosque in 1992 was an egregious violation of the law. And what does it do? It ends up giving the land on which the mosque was built to the people who violated the law.
But then, to be fair to the Supreme Court, what the Supreme Court said is this is such a jumble of facts that clearly requires some reparation as far as the Muslim side is concerned. And therefore, they insisted that 5 acres, not just this small piece of land, but 5 acres of land be given to the Muslim side. There itself, somewhere nearby, within the municipal limits of Ayodhya.
They ended up 25 miles away.
Yeah, but unfortunately, the other side concerned said, we will not take the land. It was the Waqf board which said, we are willing, and the Waqf board went into acceptance.
Again, we're going into details. I'm coming back to the point. You can't say something is a desecration, you can't say its demolition is egregious violation of the law and then hand over the property to the violators of the law. That puts the Supreme Court not just in an absurd position, but in a ridiculous position.
Well, to be very technical, they didn't give it to the desecrators, they didn't give it to those who demolished, they gave it to a trust established by Government of India. So,
you might say,
well,
it comes to the same thing.
There is a little difference, but you may think there is.
A little difference that a bit like a fig leaf covers up what I call the ridiculous outcome. That's all it does. Let me put it slightly differently to you. What would the Supreme Court have done if it was adjudicating this matter whilst the mosque still existed, i.e. before it was demolished? If in those circumstances the Supreme Court chose to give it to the Hindu side, they would have also had to either order or acquiesce in its demolition. And that would have tied the Supreme Court in knots.
Yeah, I do agree. As you know, you yourself said law is an ass, but the better version is that hard cases make bad law. And it could well be that jurisprudentially, this is about as hard a case can get, and therefore what you end up doing makes bad law. This is often said. But I hope that at the end of all this, there is a closure. I think the important
thing... I'll come to that in a moment's time, because that I think is perhaps the nub of why you've written the book. And I'm deliberately leaving it to the end. What I'm saying to you is this. Our argument clearly, I think, would suggest to the audience that this is a matter the Supreme Court should have declined, not gone into. If after having begun hearing the case and discovered that the evidence doesn't go back to 1528 and you can't rely on assumptions and you can't rely on history and you have to only rely on very limited evidence which one side has through good luck and the other side doesn't through bad luck, then the Supreme Court should have said, sorry, we can't handle it, we simply don't have the basis to do it, it wouldn't be justice. Or it should have said so at the outset. But to actually venture into this territory is to start dancing on ground that fools would not even want to tiptoe over. And
Well,
that's what the Supreme Court has done.
you know,
it's
that's all
danced
very
on
well.
ground where it shouldn't have tiptoed.
That's all very well, but you can't in our system, you can't refuse to adjudicate. If there is a title suit, if there is a civil dispute, you cannot refuse to adjudicate. That's the issue. You can refuse to adjudicate a writ petition, because a writ petition traditionally is
Then
understood
if
to
you
be...
have to adjudicate, and you have to do so on the basis of limited evidence, recognizing that it's pure bad luck that the Muslim side doesn't have evidence that goes back to 1528, then they should have split the property. It's not for the Supreme Court to be Mother Teresa and try and heal. It's not political healing the court does, it's justice.
So I think this long discussion brings us to at least one conclusion. What you're saying is, given whatever the Supreme Court had, given that the matter proceeded in whichever manner it did, at the end the Supreme Court should have split the property, as the High Court did. The High Court split it into three parts, etc. Not very satisfactory. None of the parties had accepted it. But there was also this question whether the High Court has a right to do that. As far as the Supreme Court is concerned, under Article 142, it has the power and jurisdiction.
And should have used it.
So the only
Do you agree with that?
bottom line would be that they haven't used 142. That's the bottom line.
Would you agree? Should the Supreme Court, rather than give it entirely to one side, in this case the Hindu side, should the Supreme Court have split it? That would have been more just. Even if it wasn't healing, it would have been more just. And remember, justice is what the court's about, not political touch and healing.
I agree. A lot of the questions you're asking would not have arisen if that's what the Supreme Court would have done. But I do believe that Supreme Court, by doing that, would not have put an end to the problem. The problem would have continued, perhaps become worse, and the Supreme Court there has sensibly and very judiciously tried to resolve the problem under Article 142 by giving separate property to the Muslims.
This brings me to the last point, which I deliberately left to the very end, and I'm now going to quote from your book's introduction. This is what you write. This book is an attempt to see hope in what might be a judicious decision. And then you add, and this is very important, it is imperative that we find closure and carry on with our national life. And I want to ask you, has that sentiment colored your judgment and led you to the conclusion that the Supreme Court's verdict was the correct one?
Listen, that's a very difficult question to answer. And I think that if you were to ask the Supreme Court judges, and there were not just one, it was 5 judges who decided this, and if you were to at some stage talk to those judges, they would find it difficult to answer this question. In the backdrop, there was for everybody, as indeed for me, in the backdrop there was this desire and inkling that for some reason, some manner we should find closure. Let's move on. Now, whether we found closure or not is a question of history.
But you've accepted the judgment as correct in the hope it brings closure.
Well, I do believe that, many judgments that you accept as correct have elements that you can work upon to review the judgment, to come to a different conclusion many years down the road, etc. It happens every day.
It's a bit late to come to a different conclusion many years down the road. The mosque is gone, there'll be a temple in its place. You're not going to demolish the temple, are you?
No, it's not a question of demolishing the temple. The issue is what you believe is the right thing to do in the circumstances. That's the issue.
Let me finally quote a sentence from the last chapter of your book. I think it makes explicit your thinking. If Muslims are made to feel more wanted as Indians by other Indians, the sacrifice of Ayodhya would be worth everything. The only problem with that sentence is the word sacrifice. Sacrifice suddenly raises in my mind the possibility that you've got doubts about the legitimacy of the Supreme Court's verdict. Why is it a sacrifice?
No. Verdicts could go any way. Supreme Court, as I said, Supreme Court, depending on what the combination of judges is, tends to go one way or another. Now, it's possible from my point of view.
But Salman, the point you're missing is this. If you call it the sacrifice of Ayodhya, and those are very important words, the sacrifice of Ayodhya, that suggests what the Supreme Court delivered wasn't justice, it required a sacrifice from the Muslims to restore calm and to bring closure. The
Well, I do-
Muslims made a sacrifice, and you're suggesting that's what the court
Well,
imposed for political calm and closure.
I am prepared to reiterate the issue of sacrifice, because I do believe there is a sacrifice. But it doesn't automatically, in my mind, lead to the Supreme Court judgment being wrong. The Supreme Court judgment in the circumstances could not have been any better. The Supreme Court judgment contributes to what we would contribute to by a sacrifice.
Okay.
Put it all together, and if we move forward from here, and if we learn to live like brothers and sisters again, I believe we would have succeeded.
So let me repeat what I think is the core point you're making. Number one, in the circumstances of this being a title dispute that has to be held and determined only on the basis of evidence, the Supreme Court gave the best ruling possible. That
Thank you.
completely ignores all the concerns I brought up about the nature of evidence, ignoring assumptions, ignoring history, but you can't bring that in if it's a title dispute. If you look at it narrowly as a title dispute that has to be determined on the basis of evidence available, good luck, the Hindus had better, the Muslims didn't. It doesn't matter that it was bad luck, the Muslims didn't. On that basis, the Supreme Court is right. And the second reason you think the Supreme Court is right is that they've brought closure to an issue
I hope.
that
I hope.
that
I
was
hope
tearing
it
the
has.
country apart.
Absolutely. You couldn't. I couldn't have summed it up better than you did.
But it is still a sacrifice.
Let's leave it at that then.
Salman Khurshid, a pleasure talking to you. Take care, stay safe.
Thank you. Thank you very much.